My name is Harold Paisner, and as Senior Partner Emeritus of Berwin Leighton Paisner, and on behalf of the firm, I would like to say how very delighted we are to be associated with the Criminal Justice Section of the American Bar Association to host this conference. My firm these days is very much an international law firm, with our main office here in Adelaide House, just across the road, and where, of course, the conference is taking place. But we have further offices on the continent in Brussels, Paris, Frankfurt, Berlin, and Moscow, in the Gulf in Abu Dhabi and Dubai, and in the Far East we have offices in Singapore, Hong Kong, and Beijing. We are about 830 lawyers in total worldwide. Computer and white-collar crime is a key area of our practice, both in London and internationally. Now let me say something very briefly about the Fishmongers Company. It's one of the 12 great livery companies of the City of London and is amongst the most ancient of the city's guilds. It has enjoyed an unbroken existence for over 700 years. Fishmongers Hall, the building originally on this very site, was destroyed by the Great Fire of London in 1666. And it's been rebuilt, or it was rebuilt, twice thereafter, and then was largely destroyed again by bombing in World War II. But now, as you can see, it's been restored to its previous glory. In fact, you can't see it because the blinds are down, but just across the road, behind our building, Adelaide House, there's a monument. It's called the Monument to the Great Fire of London in 1666. It's a tall column, and it's quite interesting. It commemorates the Great Fire. Now, we have a very distinguished keynote speaker this afternoon, Lord Carlile of Berriew, CBE QC, whose topic will be Cyberactivity, the role of the lawyers. Lord Carlile was called to the bar by Gray's Inn in 1970 and became a QC in 1984. From 1983 to 1997, he was the Liberal, or maybe I should say Liberal Democrat MP, that's Member of Parliament, for Montgomeryshire, and served as spokesperson on a wide range of issues, including home affairs and the law, and was leader of the Welsh Liberal Democrats from 1992 to 97. He was a founding member of the All-Party War Crimes Group and has also chaired the Select Committee of both Houses of Parliament on mental health legislation. Between 2001 and 2011, he was the independent reviewer of terrorism legislation and the independent reviewer of the government's Prevent policy. In July this year, he was appointed a member of the Independent Commission on Freedom of Information. He was appointed a life peer in 1999 and was awarded the CBE in 2012 for services to national security. He is a Deputy High Court Judge sitting in the Administrative Court and a Crown Court Recorder. So now please welcome Lord Carlile.
Thank you very much, Mr. Paisner. Can everybody hear me? Ladies and gentlemen, first of all, can I say how welcome you are to London. My wife, Alison, and I had the pleasure of meeting many of you last night at dinner in the Royal Festival Hall, and I understood then what a very special group you are with very high quality experience in the issues that form the centre of your conference. And therein lies a bit of a problem. My wife was just reminding me that some time ago I was asked to go to the town in the north of England where I was brought up to give a talk on my career. I was introduced by the vicar of the town, who read out in introduction all the details of my career, which meant I didn't have an awful lot to talk about when I got to speaking myself at my career. And much of the evening was spent trying to restrain my then 94-year-old mother from beating the vicar. My wife is Alison Levitt QC. She's a white-collar criminal lawyer too. she will verify that last night I sat down at my desk studiously preparing a speech for this lunch, but I went to the last session this morning in your conference where the entire subject matter was covered with far greater skill and expertise than I could ever offer. So over the last few minutes in my head, and you'll have to forgive me for that, I have prepared a rather different speech. And it's going to be entitled Cautionary Tales, though I will in due course come to the subject which I intended to choose, bearing in mind that you all have to be back across the road by, is it 3:30? No, I think it's 2:30. I'm going to give you 3 cautionary tales, one of which is complete nonsense, one a lesson from history, and one relevant to the subject we're choosing. And they are all about preparing for events that come upon us. The first one is a short poem. I don't know how many of you are aware of the great poems of Hilaire Belloc, entitled A Cautionary Tale, but the first one is about a boy called Algernon, who played with a loaded gun and on missing his sister was reprimanded by his father. And the poem reads as follows. I promise it won't take long. Young Algernon, the doctor's son, was playing with a loaded gun. He pointed it towards his sister, aimed very carefully, but missed her. His father, who was standing near the loud explosion, chanced to hear and reprimanded Algernon for playing with a loaded gun. That's the end of the poem. And it's a useful little cautionary tale, which all lawyers, I think, should be prepared to quote to their clients from time to time. Once I was asked to advise a clergyman who'd been injured in a road traffic accident, and he had been offered a reasonable sum in settlement of his claim, which had involved the cutting of his carotid artery, but there happened to be a doctor walking past at the time, a surgeon, who knew exactly what to do with a tourniquet. And you'll have to look this up in your hotel room, where there is a Bible in the drawer beside your bed. But I quoted back Matthew chapter 5, verse 25. It's a good lesson on why not to go to law. Anyway, cautionary tales are very important because they are something we should tell our clients. The second cautionary tale is one from history, and it's a very serious one, and I acknowledge the contribution of former First Assistant Secretary of Homeland Security for Policy, Stuart A. Baker, for reminding me of this in an article I saw in the ABA Journal in May of 2012. And it's about the cautionary tale of the aeroplane. In September 1939, a great American president, Franklin D. Roosevelt, sent a cable to all combatant nations just after the war had started, reminding them about the international limits on the use of air power. And he had a very strong case for these limits, because the Hague Convention on Laws of the War said all necessary steps should be taken to spare as far as possible edifices devoted to religion, art, science, charity, hospitals, and places where the sick and wounded are collected, provided that they are not used at the same time for military purposes. Well, we know what's happened in the last week in the context of that. And also, the League of Nations had passed a unanimous resolution on the 30th of September 1938, stating the intentional bombing of civilian populations is illegal. In June 1940, Hermann Goering, in orders for Luftwaffe operations against Britain, stressed explicitly that every effort should be made to avoid unnecessary loss of life among the civilian population. Unfortunately, on the 24th of August 1940, I wonder if Mr. Putin has read this, but on the 24th of August 1940, a German pilot made a navigational error. This is absolutely true. and a Luftwaffe group aiming for oil terminals along the Thames miscalculated and dropped their bombs on the civilian centre of London. And there ensued the Blitz, in which buildings like this were destroyed. Because Churchill immediately retaliated, not accepting that there had been any intention not to damage civilians, and hundreds of thousands of people were devastated, many killed as a result of that Blitz, arising from an error. So there's a cautionary tale about how when we have a great invention like the aircraft or the internet, we should anticipate what damage could be caused before it happens, otherwise the price is very high. And the third cautionary tale is a recent one about a man called Junaid Hussain, who was a British black hat hacker from Birmingham in the United Kingdom, England's second city. And the definition, as I understand it, of a black hat hacker is that it is someone who violates computer security for little reason beyond maliciousness and personal gain. In June 2011, Junaid Hussain published the address book online of the former British Prime Minister Tony Blair. He was caught. An investigation showed that he was the head of a hacking team, attractively called Team Poison, which at the time had claimed credit for more than 1,400 illegal hacks of foreign politicians and international businesses and so on, including one international humanitarian agency. And as a sideline, he used to make large numbers of hoax calls to the Metropolitan Police, the London Police anti-terrorist hotline, thereby preventing legitimate calls from getting through. So naturally, he was brought up before the court. And this will cause an intake of breath among Americans, I think. He was sentenced by the judge in London to imprisonment for 3 months, as a result of which he emerged from prison after 6 weeks. In fact, he probably emerged on the day the sentence was passed, because he'd been in custody awaiting trial. Had we anticipated Mr. Hussain? In July 2013, he fled to Syria to join ISIL. He was part of an ISIL group that called itself the Beatles, alongside the infamous Jihadi John, and his nom de guerre became Abu Hussein al-Britani. He became the most prolific ISIL hacker. He was behind a plot to steal millions of pounds from British banks by cyber attacks. He allegedly, almost certainly, radicalized and directly encouraged Elton Simpson, who you will recall on the 3rd of May of this year carried out shootings in Garland, Texas. And he was thought to be the head of Cyber Caliphate, which carried out various attacks of cyber vandalism over the years. As a result, he was listed as one of the 3 highest ISIL targets on the Pentagon's kill list, behind Abu Bakr al-Baghdadi, who appears to have just about survived an attack yesterday, and Mohammed Emwazi, known as Jihadi John. On the 24th of August 2015, Mr. Hussain was killed by a drone strike on his car in Raqqa, a drone strike by the British military, which has been severely criticized by some in this country as an inappropriate way of dealing with him. And you will gather from my tone of voice that I do not agree with that criticism. But what we have there is another misjudgment, a lack of anticipation of the threat an individual could cause with the skills that he had. From his 3 months imprisonment, he went on to be one of the most dangerous attackers in the world. And that really brings me to my theme in these few minutes that I have to speak to you. What should lawyers be doing to activate the world to understanding cyber activism. I don't like the phrase cyber crime because I think a lot of this activity may not quite be crime. Cyber activism that could lead to great loss. We enacted in the United Kingdom the Bribery Act in 2010. There is hardly a decent company in this country that does not have a Bribery Act policy. And indeed, they run the risk of directors of their company actually being imprisoned if they have not formed a proper Bribery Act policy. Almost every senior lawyer in London interested in this kind of work has given courses, lectures, and seminars on Bribery Act policy. Every company in the security world, Kroll and all the rest of them, every solicitor's firm interested in this kind of work has offered its services and has made company boards very aware of this kind of issue. Now, I don't know how many of you have sat on the boards of medium or large companies. I've sat for years on the board of a medium-sized company, and even raising the Bribery Act before them felt quite a challenge for them, but they did it. There was a survey carried out recently by the Ponemon Institute, commissioned by Fidelis Cybersecurity. It showed that 76% of company boards review or approve security strategy and incident response plans. But what does that really mean? Sounds very good if 3/4 of companies have already got some kind of plan, though what about the other quarter? 41% of board members admitted that although they'd heard of cybersecurity, they knew almost nothing about it. 26% said really they had to confess that they knew nothing about it. And 59% of board members believed that their cybersecurity governance practices were effective, whilst only 18% of IT security professionals agreed that their cybersecurity practices were effective. So there you have a huge ignorance in the corporate sector about cyber activism and the results it can bring. I've discussed this in some detail with a group of former UK prosecutors who are now in private practice. And they agree that there is indeed an analogy with the actions that were taken over the Bribery Act. So what is the role of lawyers? The technical skill that you have, and I suspect that the technical skill of American lawyers is probably greater on average than that of British lawyers in this field so far, should result in lawyers being proactive, just as we were over the Bribery Act, going out to companies and saying, don't come to us to solve your problem. You need to know what your problem is before you have to solve a problem, because if you know what your problem is before you have to solve the problem, you may not have a problem. Now, of course, that takes some persuasion, because company boards don't particularly like paying good money, which would otherwise go to the bottom line, to lawyers. But as the scenario this morning in the last session illustrated, the result of something they were not prepared for could end up not only in losing millions, if not billions of dollars, but in an international incident too. My answer, incidentally, to the last scenario was get the Foreign Secretary or the Secretary of State in the United States to call in the Chinese ambassador and say to him, you really want your ships to deliver goods manufactured in China to our country? Well, you better do something about this. And indeed, my worry is actually not that the situation might arise from hacking in China, but from hacking in Vanuatu or Outer Mongolia, where there is much less leverage to exercise over the government of that country. In my view, lawyers now should be out there proactively advising corporate clients, reminding them that this kind of hacking can occur from very small breaches. Did you know that something like 80% of an individual's Facebook friends are people who they've never met, who they've just ticked because they happen to be somebody else's friends? And did you know that an awful lot of those Facebook friends, if the individual is allowed to connect their own computer or their own iPhone to the company system, could be out there getting ready to hack the sort of information we heard about this morning? Well, if you didn't know, you know it now. And if you didn't know it, I can tell you that the companies concerned didn't know it. And also, in providing legal advice, lawyers must make it absolutely clear to corporations the legal obligation they must abide by. In particular, the risk of substantial fines that can be drawn against a corporation for loss of a company's customer data. In your country, the Federal Trade Commission and the Federal Communications Commission has power to obtain an injunction, restitution to consumers, and repayment of investigation and prosecution costs, with criminal penalties including imprisonment for up to 10 years for people just because they're directors of the company. They may not even have the requisite knowledge. The record fine, as I understand it so far under that regime, is a $25 million fine of AT&T in April of this year for a data breach that affected 280,000 of its customers. And indeed, the European Union General Data Protection Regulation is due to be ratified about now and will introduce the same sort of regime. We have the responsibility as lawyers, therefore, to show that at board level there is an awareness and understanding of the threat from cyber activism. We will be failing in our ethical responsibility as lawyers if we don't tell our established clients of these dangers. And we will be saving them an awful lot of money, much more than we will happily make for ourselves for doing so, if we take that duty seriously. So thank you for coming to London. Thank you for enjoying the delights of London. We don't normally buy our fish from fishmongers in places like this, but it's nice to come here. Thank you very much to Berwin Leighton Paisner for their contribution to this event. And may I wish you well for the rest of your seminar.